3 things to worry about when mediating without attorneys. Series Mediating with or without attorneys with Ty Bourdony. This is our topic for today.
Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent.
Hello and welcome. My name is Natalia Łowska-Czajka and I am an advocate, mediator, and arbitrator from Warsaw, Poland.
Hi, everyone. This is Mac Pierre-Louis, attorney mediator and arbitrator working throughout Florida and Texas.
And I'm Ty Bourdony, a professional full-time mediator and primary mediation trainer here in Central Florida.
It's good to have you all back in Ty's series concerning mediating with or without attorneys. We wanted to concentrate today on something really specific. And this is that sometimes there are situations where you do need to worry when you mediate without attorneys. And we wanted to discuss it with Ty as our most experienced mediator, what the situations we might have in mind when we think and say sometimes we need to worry when people are mediating without attorneys. What is first that comes to your mind, Ty, about it?
So when I was and great to be back. Thank you guys as always. And I really enjoy this topic because when I was the staff mediator, if there were parties who were unrepresented, they would come to me first, right? And then I would, I did plenty with attorneys, but I would get those unrepresented parties first. And I did that for almost 7 years. And so I have a comfort with unrepresented parties. It can really work well when it works. But by the same token, I am always worried when I have unrepresented parties. And the reason that you have to be worried is because they don't do this on an everyday basis. They're not familiar with the process. Why would they be? Why should they be? And they don't read law. They're not. So you can say something and they may misunderstand it, or they may not come to the process empowered like they need to, with all of the knowledge that they need to. They may not have spoken with attorneys, right? And remember, even rational folks become somewhat irrational when they can't see straight and they're dealing with something that is one of the most trying times in their lives, like a divorce. And so things can get out of hand. And I've dealt with so many pro se's that I've seen a whole bunch of different things, but a mediator needs to know how to ensure that the process is set up the right way, so that, for instance, I will tell folks when I'm talking with them, when they call me initially, this process is not for everyone. I will not do this with any pro se, right? In my mind, I will take the case where the parties are capable of working it out, that they can talk, right? That they maybe they can't stay together, but for the best interest of the child, they're willing and able to come to the table and figure it out. That's not everybody. And I will tell that to parties, and I will not say yes to everyone. And so what things do I need to do to ensure, if I tell a party, okay, I think I can help you, at that point, what does my engagement letter look like? What conversations have I had with folks? Do they know, and they better know, that they can speak to counsel? They should always have the ability to speak to an attorney. And then when we're mediating, what is it that you have to worry about? So many different things, and it's case by case. And then when you're finalizing, when you're finishing, let's say you've helped them come to agreement. Well, what about the signing process? Is it going to be the way it normally is, like in court-ordered mediations? Or do you need to put some things in place so that parties don't come back and say, hey, I felt pressured, or that's not what I agreed to, 3 months ago? You see what I'm saying?
Yes, Ty. For this first part, what do people need to be aware of. Can you tell us a couple points, both for the perspective of the mediator and from the perspective of the party, what they should be worried about?
Yeah. So let's start with the party because they're the most important ones, right? The mediator is supposed to know if you're helping pro ses, you'd better know how to do it, by the way, right? But if you're a pro se, you won't know how to do it. Why would you know how to do it? You want to ever know how to do it, right? And so for the pro ses, and this is not something that we haven't said before. We've said this many times, right? They need to be as informed as possible, right? If they want to do it pre-suit and or without attorneys. The other thing is, one of the reasons they want to do it without attorneys is they want to try and save money. And I would tell parties out there, your main motivation should not be trying to save money, right? Don't get me wrong, it's always a motivation, but you get what you pay for sometimes. And so if you want to try and do it the cheap way, you might be spending more money later on. And so be willing to pay what needs to get paid in order to get a good resolution. What I mean by that as well is I prefer that when I'm done with mediation, that the parties will then, if they've come to complete agreement, will then use an attorney and let the attorney create their documents and let the attorney represent just one of them, because everything's agreed to and there's nothing that they need to fight anymore about. And that let that attorney then file the case and take them to final judgment. This way, right? Because what happens when there's no attorney afterwards is they're not going to know what's going on, and they will ultimately call the mediator saying, "Oh, but this is happening. What's going on here? How long is it going to take me?" The mediator should not be speaking with them after they mediate. There's a good reason for that. They should have somebody else, and if they don't, because they want to be, cheap's the wrong word, but they want to save money. Well, what happens when you have a question, right? So an additional $1,000 or so to hire an attorney to represent one of you should not be frowned upon. It should be looked at as this is the price of doing business. That is the price that someone has to pay to get divorced. And it's well worth the money because it's peace of mind. And it also, when you're representing yourself, you're in line with everyone who has no attorney. Most folks don't. If you have someone representing you, or at least one of you, you're going to be able to have the most expeditious and timely, process possible. And so people just need to look at the big picture and not just either what they're worried about or money, right? And mediators need to recognize that if you're going to deal with pro ses, everybody is not a perfect candidate, and you have to let them know, I can't take everybody. If you're right, I'm very, very picky with respect to whom I will mediate with.
And if we can follow on that, Mark, I can give you the floor first, please.
Yeah, no, I wanted to make just a quick follow-up point. A mediator is not necessarily going to take on every pro se parties who call them, right? But if you are unrepresented, you don't have a lawyer, how do you make sure that you are a good candidate that a mediator is going to want to work with? Thoughts?
That's a great question, right? Yes, you're getting a divorce, but are you able to still, to some extent, civilly talk to each other? Are you able to, if you have children, for instance, in the best interest of the child, understand and come up with something that's fair between you both? Are you able to work it out? Or are you so blinded by the intense emotions and the fear, the uncertainty? It's one of the toughest times in your life, and just the anxiety that goes along with it. It can be debilitating, right? And so people get lost in the argument, and that's all they have left sometimes. Can you still try and work it out with the other side? There are plenty of people who can, and there are tons of people who can't. Those that can't, you need attorneys, or in Florida, if you file a family case, you will be sent to mediation. Go file it and go see someone like me when I used to be the staff mediator and go through the courthouse mediation, right? But a mediator needs to be very worried if you're going to do it privately beforehand, right? Some people are better suited to go to the courthouse mediation, and some people, a lesser amount of folks, can go do it privately and do it pre-suit. Those that can, those that are able to work together so that they can get past it, create their own, those that create their own agreements successfully, typically they can stick to those agreements. But when you're forced into an agreement by someone in a black robe who doesn't know you, people don't like that sometimes, and you're going to have to deal with that. So if you can get along to some extent, if you can, for now, let's get through this, let's work together. If you can do that, you're a good candidate as a pro se party, an unrepresented party, to do it yourself, right? But if you can't, you need attorneys and you need court, you need the judge, potentially.
And when we already have those processes in mediation, one party or two parties who are unrepresented, how should a mediator set the stage so that it's comfortable for the process parties, and especially to try to combat the imbalance that is being created that one party is with an attorney, the other is without, but
Right.
also to ensure that they are able to mediate in a fair and balanced mediation process?
Right. That's a great question. One, I think a mediator needs to ensure that everything they do always has the effect of it giving the impression that they're being transparent. We are both parties mediators, right? They both need to not only be aware of it and know it, they need to believe it. And so the way you communicate with the parties as the mediator and the way you set it up in your initial conversations with the parties, for instance, inevitably either I have a represented party and an unrepresented party. And if I have an unrepresented party, it's probably because that attorney has mediated with me before and likes me for that particular case for some reason, right? Or one of the parties found me online, right? And they called me. Now, this other party, the one who either is unrepresented and it's the other party's attorney who recommended me, or the other unrepresented party who said, hey, I think I found a good mediator, I have to make sure that that other unrepresented party can still look at me and believe me, can still think that I am, able to not only be neutral, but that I'm never going to be anything other than fair, right? That they can trust me. So I'm always going to be vested in trying to build that trust between the parties, but more so that they see me as someone who they can work with and trust. And all of my communications have to be transparent. And when I talk to that first party, it's really important for me to tell them, listen, I want to speak to the other party, just me and them, right? And please don't worry, I'm going to talk to them just the way I'm talking to you. You're going to at all times make sure to stress, I can't give you legal advice. You have the ability to speak with someone. You should consider speaking to someone. Know what those resources are. A local bar association is easily a good recommendation, right? But again, it's just simply setting the stage so that they, one, trust you, and two, that at all times they know no one's going to force you to do anything. You always have the ability to talk to somebody, right? And giving them a good idea of what the process is, how long it's going to take, and knowing what you're talking about. And if you don't know how to deal with pro ses, maybe you shouldn't be dealing with pro ses as a mediator.
Yeah. So when I was a former teacher, one of the things that we always had to live by was when it comes to kids, you tell them what you're going to teach them, you teach them, and you tell them what you just told them. Right. And so as a mediator, you have to do a really good job of laying down what they're going to experience, telling them about the process that they're going to be going through. Because people are creatures of habit and predictability. We need to know where we're going. Nobody wants to be taken for a ride. Okay. And you'll help A mediator would help the pro se person, and the pro se person will feel helped if they understand the route and the path they're about to go down. So now, let's say, Ty, out of these 3 steps, we're in the middle section where the mediator is now in the thick of it. They're helping the parties mediate. They're helping the parties put on their issues on the table, frame things correctly. And the dialoguing is taking place, and they back and forth, back and forth. It gets emotional, it gets stressful. And now you can see the light at the end of the tunnel. You see that these parties actually have something that they agree on. And now you are about to bring them into a settlement agreement on most of the issues, on all the issues. What now, Ty, at this step, this third part, what now should the mediator be worried about? And what should the parties be worried about to make sure that they're about to enter into an agreement that the parties are actually going to live by and not give each other problems going forward into the future?
Right. Let me parse that out into 2 parts. One, during mediation and right before we make that light at the end of the tunnel move, and then light at the end of the tunnel and coming to agreement. So while we're mediating, there's every mediation is different. So there's you're always reading the temperature in the room, and in that moment, based on what's going on, the mediator has to decide how best to move forward. One of the issues, so recently, in this case, I recognize, wow, things are getting rather heated. And it seems to me that the parties have not sought legal advice. They need to seek legal advice. I think I should stop mediation right now and set the stage in order for us to be able to move forward if we can. So knowing, for instance, that maybe I should stop mediation, knowing when to call caucus, right? Getting the understanding that, okay, we're going around and around in circles. They need some legal advice, right? And so recently I stopped the mediation and I let them know, look, I got to be honest with you. I really believe that the 2 of you need some legal advice, and then we're going to be able to hopefully move forward. And to be quite honest with you, both of them said, well, but we don't know who to go to. And then I said, let me ask you a question. Would you both agree that I can give you each 3 different attorneys that you can go get just a consultation from? There's a difference between a consultation and retaining an attorney. But if you want to retain them, you can bring them to mediation, right? Again, being open, being transparent. And then, so I stopped mediation. I gave them both 3 different names. They sought the legal advice, and then they came back to mediation, and we were able to then move forward. Right. So what's my point? My point is, in the middle of mediation, there will be difficulties, and the mediator needs to understand from a nuanced and experienced way, what's going on here? How do I handle it? How am I able to get them to move forward? Every case is going to be a little different. That's what the last case was. And then let's say that goes well, and we're now coming to agreement. So what does the mediator need to worry about? What do the parties need to worry about? So let's say we're in the courtroom, right? When you're in the courtroom and in the courthouse mediation setting or court-ordered mediation setting, you come to agreement. Typically, the mediator will sign it. We'll type it all up. Everyone will review it, and then we'll sign it electronically if we're doing virtually or what have you. Now, if you're doing a pre-suit or a mediation with pro se parties, I am not going to allow us to type it up, read it, and then sign it right then and there. On the contrary, I'm going to be very specific with them. I'm going to say, look, okay, great. We've come to agreement. Let me type it up. Okay. I'm going to send it to you both. I want you both to review it. I want you both to take it to someone to read it, and then get back to me and tell me what needs to be changed. What are you comfortable with? What are you uncomfortable with? And that's not tomorrow. I'm going to give them days, if not a week, before we meet again to then go over everything again. Right. And if we are comfortable at that point, after I've given them the ability to get it reviewed, right, and given me the chance to change what they need to change, with them understanding, once you sign, right, this agreement is going to be potentially binding on you. The reason I want to give them time is so that they cannot say, I felt pressured. I felt like I had to sign it. I didn't get a chance to review it. On the contrary, and in my emails, I'm going to be very clear. Please make sure that you get this reviewed. Please let me know what you want to change. Please let me know how best to move forward. And then let's talk at a later date within X amount of time so that we can schedule when we're going to sign it. And I will also either have a notary, or I'll give them notary blocks on a second signature page for them to get it notarized afterwards if they're going to do it without attorneys, right? Thinking when it gets taken to court, if they don't have an attorney, it should be notarized. But there's a lot of different steps because I want to ensure that someone isn't going to say, I felt as if I didn't have a choice. I felt as if I had to do this. I felt as if, on the contrary, a good mediator who's dealing with pro ses needs to understand that they need the ability to speak with someone and to understand the issues that they may not understand and to sleep on it, right? Because in normal mediation, we'd like it to be signed right then and there so that we don't have issues, because we know what happens when people leave. They get buyer's remorse. But when I'm dealing with pro ses, I want them to get buyer's remorse. I want them to be entirely sure that this is what they want to sign when they sign it. Because inevitably, every once in a blue moon, someone will come back 3 or 4 months later and say, but that's not really what I intended. If I set the process up in such a way that they're given ample opportunity, that they're told to have it reviewed, that they're not being forced to sign it right then and there, but 2 times, right, a week after they've changed everything, and then taking it to a notary, right, that helps the process so that if there ever is an issue at the court level, are they going to say, oh, they were given the opportunity, or are they going to say, oh, it looks like they were forced? A mediator needs to be concerned about those things as well, as do the parties.
And thank you for that, because it's time for us to close up. I want to just one more thing to sound very clearly, and this is that all these precautions are to serve everybody in the mediation. They will serve the pro se party, they will serve the mediator, and they will serve the party who is represented by the lawyer.
And the process, right?
And yeah, absolutely. So please consider that, being a pro se, being a party represented by an attorney, or being a mediator. And until the next time, bye.
Take care. Thank you, guys.